Welcome to literary and jury charge practice. Let's start out with some jury charge. Ready? Here we go. You may consider whether a party failed to explain or deny some unfavorable evidence. Failure to explain or to deny unfavorable evidence may suggest that the evidence is true. Some documents prepared in this case have been redacted to remove certain private information from them. Do not draw any conclusions from the redactions or attempt to guess what information may have been redacted. During the trial, you heard testimony read from a deposition. A deposition is the testimony of a person taken before trial. At a deposition, the person is sworn to tell the truth and is questioned by the attorneys. You must consider the deposition testimony that was read to you in the same way as you consider testimony given in court. A party may offer into evidence any oral or written statement made by an opposing party outside the courtroom. When you evaluate evidence of such a statement, you must consider these questions. 1. Do you believe that the party actually made the statement? If you do not believe that the party made the statement, you may not consider the statement at all. 2. If you believe that the statement was made, do you believe it was reported accurately? You should view testimony about an oral statement made by a party outside the courtroom with caution. People have a legal right not to disclose what they told their attorney in confidence because the law considers this information privileged. People may exercise this privilege freely and without fear of penalty. You must not use the fact that a witness exercised this privilege to decide whether he or she should be believed. Indeed, you must not let it affect any of your decisions in this case. During the trial, you heard testimony from expert witnesses. The law allows an expert to state opinions about matters in his or her field of expertise, even if he or she has not witnessed any of the events involved in the trial. You do not have to accept an expert's opinion. As with any other witness, it is up to you to decide whether you believe the expert's testimony and choose to use it as a basis for your decision. You may believe all, part, or none of an expert's testimony. In deciding whether to believe an expert's testimony, you should consider A. the expert's training and experience, B. the facts the expert relied on, and C. the reasons for the expert's opinion. The law allows expert witnesses to be asked questions that are based on assumed facts. These are sometimes called hypothetical questions. In determining the weight to give to the expert's opinion that is based on the assumed facts, you should consider whether the assumed facts are true. If the expert witnesses disagreed with one another, you should weigh each opinion against the others. You should examine the reasons given for each opinion and the facts or other matters that each witness relied on. You may also compare the expert's qualifications. Burbank claims that Ms. Gullion could have avoided some or all of the harm with reasonable effort. To succeed, Burbank must prove all of the following. 1. That Burbank had harassment complaint procedures in place and took reasonable steps to prevent and correct workplace harassment. 2. That Ms. Gullion unreasonably failed to use Burbank's harassment complaint procedures. And 3. That the reasonable use of Burbank's procedures would have prevented some or all of Ms. Gullion's harm. You should consider the reasonableness of Ms. Gullion's actions in light of the circumstances facing her at the time, including her ability to report the conduct without facing undue risk, expense, or humiliation. If you decide that Burbank has proved that Gullion unreasonably failed to use Burbank's harassment complaint procedures, you should not include in your award of damages the amount of damages that Ms. Gullion could have avoided. If you find in favor of Burbank on Ms. Gullion's claim that she was harassed, you must also find in favor of Burbank on Ms. Gullion's claim for failure to prevent harassment. If you find in favor of Ms. Gullion on her claim that she was harassed, you must also find in favor of Ms. Gullion on her claim for failure to prevent harassment. I am turning now to the question of damages and what can be considered in determining an award of money in this case. By including damages in these instructions, I do not wish to suggest or imply anything about whether liability has been proved or about whether damages have been proved in this case. All right, let's take a little rest our fingers. Next, we will practice some literary material. This is called How to Talk Tech. Ready? Here we go. How can I avoid getting ripped off when I get my car repaired? Yours is a common concern, to be sure. According to a new AAA survey, 2 out of 3 car owners don't trust auto repair shops. The late Ken Purdy, among the best automotive writers of his time, wrote about a mechanic who called himself Honest Eddie. He wouldn't steal a whole car, just parts of it. He'd double talk some poor sucker into replacing a part that wasn't defective. The portoflan opening on the coil is clogged, he'd say. In went a new coil. The old one was stuck in a box and sold the next day as factory rebuilt. In truth, these days, Honest Eddies are few and far between. Both independent and new car dealer repair shops have massive investments in facilities, tools, and diagnostic equipment and need repeat business. They don't need a bad rep, and they're also subject to strict oversight by the California Bureau of Automotive Repair, BAR. But like a tax audit or a cracked tooth, an unexpected budget-busting car repair can ramp up your blood pressure. You're stressed, and your mechanic, technician, or tech, as they're called these days, has the delicate task of confronting you with bad news. It's a recipe for conflict. The antidote? Good communication. Here are some suggestions for finding common ground. First, your responsibilities. Be specific when describing a problem. There's a high-pitched squeal between 50 and 60 miles per hour that seems to come from the rear wheel on the driver's side. is a lot more helpful to the technician than the wheel makes funny noises. Mention all your observations even if they seem silly. A sweet smell, for example, might lead the tech to suspect a coolant leak. Don't self-diagnose. Like doctors, technicians hate that. Honest Eddie once had a customer announce what was wrong with his car and insist that he wouldn't pay a dime more than $265. And that's what Honest Eddie charged for a few bucks worth of parts and a few minutes to fix a minor problem. Diagnosing fiendishly complex modern cars is the tech's job, and automakers have established procedures to determine the cause of a problem. Despite your expert diagnosis, you may be charged a diagnostic fee before repairs can proceed. All right, we will get back to that article. For now, let's practice some of this closing argument. Ready? Here we go. Obviously, he has to take it out of the holster to load it or make sure it's loaded if you're going to shoot someone with it. Then he brings the gun and the holster with him to confront the homeowner. Why would he bring the holster with him? Then you would have to believe he forced Ms. Rios out at gunshot, then heads her to the chicken coop rather than shooting her in the car or the dirt outside. Why would he force her in there? And then this is the craziest thing you would have to believe the burglar theory, that he shot her, and then rather than stealing the gun, he hides the gun and the holster underneath a bunch of stuff in the chicken coop. Why wouldn't he just steal the gun? If you believe he's a burglar, he likes guns. There were guns on the blanket full of stuff that he was going to, quote, steal. You saw a photo of that blanket. Then he leaves without taking anything from the house. All that effort committing a murder and not even bothering to get away with anything of value. I mean leaving her purse in the car. There's nobody else home. There's no evidence that police were coming. There's no evidence that neighbors were on their way. Now, it's true that evidence of the killer's identity is circumstantial, but it's a very strong circumstantial case here. It's like, the boy stealing the cookie, the hypothetical I gave you. That was all circumstantial evidence, but it was very good evidence. No one single piece of evidence is proof beyond a reasonable doubt. You can always come up with potentially innocent explanations for any single piece of evidence, but you were chosen as jurors for your common sense to come up with the right verdict. You have to look at all the evidence as a whole, not just the individual pieces. You add it all up, he's guilty. I'm going to ask you to return a verdict of guilty, and I thank you very much for serving as jurors. The defense attorney will get a chance to talk to you in the afternoon. Then I will have a chance to give a rebuttal. Thank you very much. that's the end of that closing argument. Let's get back to our literary on how to talk tech. Ready? Here we go. Avoid using technical jargon unless you really know what you're talking about. Plain language will minimize the possibility of the tech going on some wild goose chase at your expense. Most important, ask questions if there are any terms, explanations, or charges, anything that you don't understand, before you authorize a repair, and afterward if necessary. Don't be shy. Here's what to expect from the repair shop. Good answers to all your questions. In a small independent shop, you'll likely talk directly with the tech. In a big dealership, you'll probably talk to a service writer, typically a salesperson who might never have turned a wrench. Regardless, if you want an audience with the tech working on your car, a good service writer should arrange a meeting, and upon request, a shop should show you the defective parts before work is done. A written estimate itemizing everything before work begins, as required by the BAR. The shop must stick to the estimate unless you authorize any changes, so never sign a blank work order. Options and priorities for repairs. Some repairs can wait, and a good tech should explain that to you if you're concerned about your budget. Of course, conflict is less likely if you trust the shop to do right by you. That's why the Auto Club set up its approved auto repair program. Besides meeting stringent quality standards, shops must 1. Provide a 24-month, 24,000-mile parts and labor guarantee, and 2. Agree to accept the Auto Club's decision in resolving any dispute between you and the shop. Right. Now let's get back to some jury charge practice. Ready? Here we go. If you decide that Ms. Gullen has proved her claim against Burbank, you also must decide how much money will reasonably compensate Ms. Gullen for the harm. This compensation is called damages. The amount of damages must include an award for each item of harm that was caused by Burbank's wrongful conduct, even if the particular harm could not have been anticipated. Ms. Gullen does not have to prove the exact amount of damages that will provide reasonable compensation for the harm. However, you must not speculate or guess in awarding damages. Damages which are speculative, remote, imaginary, contingent, or merely possible cannot serve as a legal basis for recovery. However, recovery is allowed if claimed benefits are reasonably certain to have been realized, but for the wrongful act of the opposing party. The damages claimed by Ms. Gullen for the harm caused by Burbank fall into two categories called economic damages and non-economic damages. You will be asked on the verdict form to state the two categories of damages separately. If you decide that Ms. Gullen's harm includes future economic damages, then the amount of those future damages must be reduced to their present cash value. This is necessary because money received now will, through investment, grow to a larger amount in the future. Burbank must prove the amount by which future damages should be reduced to present value. To find present cash value, you must determine the amount of money that, if reasonably invested today, will provide Ms. Gullen with the amount of her future damages. No fixed standard exists for deciding the amount of non-economic damages. You must use your judgment to decide a reasonable amount based on the evidence and your common sense. To recover for future pain and suffering, Ms. Gullen must prove that she is reasonably certain to suffer that harm. For future pain and suffering, determine the amount in current dollars paid at the time of judgment that will compensate Ms. Gullen for future pain and suffering. You must not include in your award any damages to punish or make an example of Burbank. Such damages would be punitive damages, and they cannot be a part of your verdict. You must award only the damages that fairly compensate Ms. Gullen for her loss. All right, we will stop there. That will conclude our literary and jury charge practice.